Hi everyone, welcome. My name is Rhodes Donald and I'm talking today with Michael Wynne, a lawyer of Dunedin and a partner at Wilkinson Rodgers, a local law firm here in Dunedin. The topic I've asked Michael to talk about today is wills. So thank you for coming along, Michael. Appreciate this. What are some of the dangers and fishhooks around wills?
Well, Rhodes, one of the difficulties we see is people that don't keep their wills up to date, or in fact don't even have a will. And it's amazing how many people do their family a disservice by not fronting up and making a will. Also, if you don't regularly review your will, you can cause a bit of damage to the family funds. It's really important that people regularly review what their instructions are when they're no longer here, because it's too late to change it once you've gone. So you really should be looking at your wills every 5 years, or if there's a major event in your life, which could be change of your relationship status, or inheriting money, or some children dying, all those sorts of things. So those things should trigger your memory to at least review your will. Yes, because if you don't, and somehow your will is invalid, or you don't have a will at all, then it's going to cause your family a bit of grief, because then the government decide who gets what for you under the Administration Act, and I'm sure it wouldn't be what most people would want to happen with their family's wealth. Yeah. It's just on there to explain what happens if you don't have a will, or if your will becomes invalid for some reasons. I'll come back to that in a minute. For example, if you died and your surviving spouse, there was a surviving spouse and no children and no parents alive, then the surviving spouse takes everything, which is generally fine. But it becomes more complex if there's a surviving spouse plus children, because the Administration Act says then the spouse takes the first 155,000 plus 2/3 of the residue, and the children get the remaining 1/3 of the residue on statutory trusts, which isn't always ideal, because if there's a house involved, the children are going to own some of the house with mum. Or might not necessarily be mum, it might be stepmum. So also, if you, in the circumstance where there's a surviving spouse but no children, but surviving parents or a parent, then it's split again. The surviving spouse gets 2/3, the 155,000 plus 2/3, and 1/3 of the residue goes to the parents. So those sort of things aren't probably what most people would want to happen. Most of us wouldn't see ourselves giving our parents money when we die. So it's important that don't let the government decide who gets what.
Yes, and I suppose also if there's no will, or there's an invalid will, then it's going to cost a lot more. Having people, lawyers, wade through, making sure everyone's happy and so on.
Yes, it can cause some complexities. Certainly does cost more. Sometimes not a lot, depends on what the assets are, of course, in the estate, and how complex the families are. I mentioned before that you can have a will, but it becomes invalid for some reason. Some of the common reasons for that happen quite innocently. That people have made a will, they may have been in a de facto relationship for some time, and then they marry. As soon as you marry, your will is invalid. Most people don't realise that, but that catches a few out. So if your marital state, or if your relationship status changes, for goodness sake, make a new will, otherwise you'd be in bother.
And like if your marital status changes,
yes.
Well, just to put it in the lingo of the person on the street, I mean, if you get divorced, if your spouse dies,
yes,
those sort of things.
Yep. So if your spouse dies, or you get divorced, or you enter into a new relationship,
yep, Yes.
or you change it from being de facto to married or in a civil union.
Yep.
That's another change. So all of those things trigger issues that you should be aware of. But particularly bad, it's only marriage or civil union, if you enter into that, that invalidates a will. The
Right.
others, you should think, well, I need to review my will.
For instance, if you separate, now that's a traumatic experience.
Yes.
And you're not divorced. In fact, you're hoping probably to get back together.
Mm.
So that must be a time when people would perhaps not think about their will, and because it's often a fluid situation.
Yes, that's right. But for most, they'll end up having to go to lawyers to try and sort out the division of the relationship property anyway, and they would be then advised to make new wills.
Yes.
So you'd make them as the will. Generally, people would make their wills as though their former spouse wasn't on the scene anymore. But of course, those that don't make new wills and never divorce, and we see a number of those where you'd be separated for 20 years but still married. Now, your former spouse can still, you haven't changed your will and haven't done a proper division of relationship property. Your former spouse is going to have a claim against your estate.
And it could be that they actually own your insurance policies.
Correct.
That you've never bothered to change the ownership of.
That's right, yes.
Life insurance policies.
Yes, that's right. You've got to really have a good review of everything when you're in that unfortunate position.
Michael, I was just thinking too, my father in his dotage in his late 90s, he decided he wanted to amend his will, but he didn't like paying fees to anyone. So he started writing all over his will in a red pen. And these were explicit instructions about what would happen. Well,
Yes.
Some of the things he wrote were contradictory.
Yes.
But, as soon as I saw it, I said to my brothers and sisters, well, that will's no good. We've got to start again. What's the situation there?
Yeah, well, each on its own facts, of course, but it is possible now to have a will such as that validated as a valid will by the court. Prior to 2007, you wouldn't have been able to, because we were acting under the 1837 Wills Act, which didn't have such a beast. But
that's an old act, isn't it?
Yes, since 2007, we've had this new Wills Act, also a new will, it's 13 years old now, but it has a provision in section 14 that allows the courts to validate a will that wouldn't meet the requirements of a valid will. So if it's a mishmash of instructions written on something, but and maybe not even signed or dated, but if it looks like it's supposed to be a will and adequately disposes of the estate, then it can be validated, as long as all the people that are eligible to benefit from inherit from the deceased, as long as they all sign affidavits, sworn statements to say that they agree with it, then it can happen. So Dad's will, the handwritten all over his valid will, could be validated.
Well, look, I wouldn't want to go down the path of having all my brothers and sisters agree on the scribbles, and it's going to cost more money. So the obvious thing is to redo the will, isn't it?
Well, you can't redo the will once he's dead, though. That's unfortunate.
No.
But you can do, what some families do. They say, look, we know this is all contradictory, and it's, he was probably losing his marbles a little bit, perhaps. Let's do a deed of family arrangement, and let's just agree this is how we think it should have. The dad really wanted it done, and so we'll agree as all the children that we'll all share it equally or do whatever. So it is possible to do that without going to court.
Yeah. Yes. Michael, at what age should someone have a will? Because we talk to the children of our clients, and yes, I'm just not quite sure at what age we should be saying to them, go and see a lawyer.
Right. You have to be 18 to make a will, but you can do it from age 16 if you get the court's consent. Never seen that done. Can't think of a circumstance where it would be warranted. Perhaps if a child become orphaned and was given a whole lot of money or something, they may do that, but haven't seen it. But certainly can. Most 18-year-olds wouldn't have requirement for a will, but they can make one. But certainly, as soon as you get a few assets around you, then it's a good idea. You know, KiwiSaver is the common one now.
Yeah.
The youngsters mightn't have got into their first home, but they may have some savings in KiwiSaver or the bank. So it's a good idea for them to make a will. Otherwise, it all goes to mum and dad.
Yeah, I see. And also, they might have a life insurance policy at some stage.
Yeah. Yes. Yeah, so it's a good idea for them to make a nice simple will. It doesn't cost much. Some lawyers still do free wills, not many. Yeah.
Well, look, I've always said to people, don't go and get a free will. Don't go to someone who does wills on the side. Go to a lawyer who specializes in this area. Don't be a cheapskate. Spend a little bit of money, get some good advice, and it's likely to help you in the long run.
Yes, good advice, Rhodes. Same with the online wills kits that you can buy from probably some American firm. Buy it online. Do your own will.
Yes.
A great source of revenue for lawyers trying to fix the mistakes later.
Yeah. No. All right. Now, are there any important considerations for the people should think about before they go to see the lawyer and make a will?
Yes, I think you really need to consider who you want to benefit from your will. And you know, these days there's a lot of complexities in families. We have lots of blended families. And, one of the common occurrences I see where people have a family when they're very young, and then they get divorced and they become estranged from the children and don't see them ever again. But you know, under the law, they owe a moral duty to provide for those children who they've never seen. So you know, there's a bit of a conundrum there. So that's where, you know, people can talk to us and we can help them out there. So a lot of people in that situation may consider doing a family trust and putting all their assets in there, so it just cuts out those children for whom you've got a moral obligation but don't feel that way.
Yep.
Yeah.
And what about something that I had to tackle with quite late in life is who is going to look after my child if both of us are dead?
Testamentary guardians, it's a
Guardian.
common one. Unfortunately, it's not the be-all and end-all. You put them in your will, you appoint a testamentary guardian, but that really gives them very little in the way of any powers. If you intend that they have parental powers, then they have to apply to the family court for a parenting order. But bear in mind too that biological parents automatically have the right of guardianship.
Yes.
So if you're estranged, you know, if you've got an ex-spouse somewhere who doesn't have the day-to-day care of the child, well, legally they can apply to be, you know, they are a guardian. They would still probably need to apply for a parenting order.
Yep. Now I was thinking just of an everyday couple who are just going to.
You should appoint guardians. It's an indication. First of all, make sure that the guardian agrees to do it.
Yeah.
So put that in your will because it's an indication of who you wanted. Of course, if something untoward has happened or circumstances have changed, the person you've appointed, the family tend to sort these things out.
Right.
But it's always going to end up in the family court to sort it out.
Yeah.
But once the children are sort of teenage years, or even from 10 or 11 onwards, for most children, it's not difficult because the judge will just ask them directly what they want to happen.
Yeah.
Who do you want to live with? Yeah. So it does make it easier because the last thing you want to be doing is, you know, children have lost their parents and all of a sudden they're
jumped it off somewhere that they had no idea.
Exactly.
Oh gosh. Well, that's another reason to keep it up to date, I suppose.
It is, yes. That's what I say regularly. 5 years minimum for those life-changing experiences. The other thing to be aware of is claims against your estate. You know, if you don't do your will properly, then there could be a claim against your estate because, as I said before, you owe this moral obligation to provide for your spouse and your children, and no wider than that. Otherwise, they can bring a claim against your estate. So the Family Protection Act allows your spouse, your children, your stepchildren if you have financially supported them, your parents if they've financially supported them, and your grandchildren if you haven't provided for their parents. So that's the only group that can make a claim against your estate. It doesn't go, as far as sisters and second cousins, just that narrow group. So if you haven't provided for that group and any of them get disgruntled, they can make a claim. Another reason for a family trust.
Okay, we'll talk about that at another time, but Michael, we'll call it quits there. Thank you very much for your time.
Okay.
Really appreciate that. It's a really basic need that everyone needs to be thinking about. Prior to COVID lockdown, well, of course, were we going to survive it? Did we have a will? Was passing through a lot of people's minds, I bet.
Yes, it was. Yes.
We survived, most of us, other than the 19 who didn't. But a good reminder to go and check that our wills are up to date.
Yes. Good advice, Rhodes.
Thank you for your time, Michael.
Thank you.
See you later. Thank you. Bye.